The HOA gave us 14 days to spend $18,000 we didn't have. If we refused, the fines would start automatically. If the fines kept growing, they could place a lien on our home. The violation wasn't a broken fence, it wasn't an abandoned car, it wasn't unpaid dues. It was our front yard. The same desert landscaping the HOA had approved 18 months earlier. Across the neighborhood, trucks started delivering fresh rolls of sod. Neighbors who had spent years removing their grass were putting it back out of fear. Water restrictions were still in effect. Southern Nevada was asking homeowners to conserve every gallon they could. Our HOA wanted us to do the opposite. And the strangest part? The board insisted. They were simply enforcing the rules. 3 houses on our street put their grass back the same weekend. By Monday morning, rolls of fresh sod covered front yards that had been dry for years. Landscaping crews worked before sunrise, unloading pallets of grass while temperatures were already climbing toward 100 degrees. Nobody celebrated. Nobody stood outside to admire the results. The homeowners signed the invoices, nodded at the workers, and went back inside. By noon, the sprinklers were running again. Water flowed into the gutters while local news stations counted down the days since the last measurable rainfall. At the time, I thought it was strange. Looking back, it was the first warning sign. Southern Nevada had spent years telling homeowners to save water. Billboards along the highway reminded drivers that every gallon mattered. News anchors talked about reservoir levels the way other states talked about the weather. Restaurants stopped serving water unless customers asked for it. Commercial properties removed decorative fountains. Everyone was being told to adapt. Everyone except our neighborhood. Every morning before sunrise, our subdivision sounded exactly the same. Hundreds of sprinklers turning on at once. The sharp clicking of irrigation timers. The hiss of spray hitting concrete. Water drifting across sidewalks before disappearing into storm drains. The sound lasted 20 minutes. The water bill lasted all month. By July, our front yard had become the most expensive thing we owned that nobody in our family actually used. Our kids never played in it, nobody sat on it, nobody walked across it unless they were getting the mail. It existed for one reason, so people driving past our house could see it. One Tuesday morning, I opened our water bill and stared at the total long enough for my coffee to go cold. I read the number twice. Then I walked outside and looked at the lawn. Nothing about it felt worth that amount of money. Not the narrow strip beside the driveway, not the patch near the mailbox, not the decorative ring around the palm tree. The grass looked perfect. Our budget didn't. That evening, I walked the dog through the neighborhood and started noticing things I had ignored for years. Broken sprinkler heads sprayed directly into the street. Water pooled along the curbs. Entire sections of grass stayed green even when nobody was home. No one seemed bothered by it. Nobody asked questions. Nobody wanted to be the first person to stop. At the next HOA meeting, the board spent 20 minutes discussing holiday decorations. They spent 10 minutes discussing parking violations. They spent less than 3 minutes talking about water conservation. No changes were proposed. No landscaping guidelines were updated. The handbook still described green lawns as the visual standard every homeowner should maintain. I drove home that night with the windows down. As I turned into our neighborhood, sprinklers activated one house at a time. The entire street came alive with the same sound. It felt automatic. Not just the irrigation systems, the people. Everyone followed the routine because everyone else followed it too. 2 weeks later, I saw a landscaping truck parked outside a house 3 doors down. workers removed the grass. They installed gravel pathways, native plants, and drip irrigation. The transformation took less than 2 days. The yard looked clean, modern, like it belonged in the desert surrounding us. Neighbors slowed their cars to look. A few stopped to talk. Someone posted photos in the community Facebook group. The comments turned hostile almost immediately. People complained about property values. Someone asked whether the HOA had approved the changes. Another resident wrote that if one yard changed, the entire neighborhood would lose its identity. Nobody mentioned water. A month later, the same house had grass again. No explanation, no discussion. The landscaping crew returned on a Saturday morning. By Sunday evening, the gravel was gone. The sprinklers were back on. I remember standing in our driveway, watching the workers roll out fresh sod. The homeowner never came outside. That wasn't the only house. By the end of the summer, 3 families had removed their desert landscaping. 3 families had put it back. Nobody talked about why. People just lowered their voices whenever the subject came up. That's when I started asking questions. The answers never made sense. Another mentioned community expectations. Someone else said it was easier to comply than fight. Fight what? Nobody explained. That word stayed with me. Fight. As if changing your own front yard meant entering a battle nobody wanted to discuss. That night, I searched for alternatives to traditional lawns in southern Nevada. The same word kept appearing: xeriscaping, native plants, lower maintenance, lower water usage, lower monthly costs. The numbers were impossible to ignore. Our front yard consumed thousands of gallons of water every month. A desert landscape could reduce that dramatically. Less water, lower bills, fewer repairs, more control over our own property. For the first time since moving into the neighborhood, keeping the grass felt irrational. The following weekend, we visited a nursery outside Henderson. Rows of agave, desert marigolds, red yucca, and globe mallow stretched across the lot. Everything looked like it belonged exactly where we lived. Not imported, not forced, real. A landscape designer explained how drip irrigation worked. She showed us examples of completed projects across southern Nevada. None of them looked neglected. None of them looked unfinished. They looked intentional. Driving home, I realized something that should have been obvious years earlier. Our neighborhood wasn't trying to fit into the desert. It was trying to hide from it. The next morning, I turned off our sprinklers. Within 2 days, people noticed. A neighbor asked whether our irrigation system had failed. Someone left the number of a sprinkler repair company in our mailbox. Another resident asked if we were selling the house. I smiled and told them we were considering new landscaping options. Their expressions changed immediately. Not angry, concerned, as if I had said something risky out loud, as if there were consequences nobody wanted to explain. That's when I remembered the 3 houses that had put the grass back. Nobody had forced them, at least not openly, but something had. And for the first time since moving into the neighborhood, I wanted to know what it was. The decision to remove our lawn wasn't impulsive. Before we touched a single sprinkler head, we checked the rules. Then we checked them again. Our neighborhood handbook filled an entire binder. Paint colors, mailbox designs, holiday decorations, fence heights, landscaping requirements. Everything had a section. Everything had a process. The landscaping chapter described approved plant types, irrigation methods, and maintenance standards. It mentioned appearance, it mentioned upkeep, it mentioned architectural review. It never required grass. It never prohibited desert landscaping. That mattered to me. I wasn't trying to challenge the HOA. I wasn't trying to make a statement. I wanted lower water bills and a yard that made sense in southern Nevada. Nothing more. The application process was straightforward, at least on paper. I measured every section of the front yard. I photographed the existing irrigation system. I sketched the property lines. Then I sat at the dining room table and started filling out forms. Plant lists, material samples, irrigation diagrams, elevation photos, estimated completion dates. Everything had to be uploaded through the community portal. Nothing could be left blank. Nothing could be estimated. Nothing could be assumed. The HOA wanted details. I gave them details. A local landscape designer helped finalize the plans. She recommended agave, red yucca, globe mallow, and desert spoon. Plants that survived Nevada summers without constant watering. Plants that belonged there. We added decomposed granite pathways and a drip irrigation system designed to reduce water usage. When the plans were complete, I uploaded every file. Then I waited. A week later, the board requested revisions. Not major ones. They wanted the decorative stone color changed. They asked for a different border around the mailbox. They requested an updated irrigation diagram. That mattered too. It meant someone had reviewed the application. Someone had looked at the plans. Someone had approved the concept. I made every change they requested, uploaded new files, resubmitted the application. Then I waited again. 2 weeks later, an email notification appeared on my phone. I opened it standing in the grocery store checkout line. Your application has been approved as submitted. That was it. No warnings, no conditions, no expiration date, no mention of future reviews, just approval. I read the message twice. Then I forwarded it to myself. When I got home, I downloaded a copy. I saved it to my laptop, printed another for the kitchen drawer, saved screenshots on my phone. At the time, it felt excessive, but the project had cost too much money to leave anything to chance. The landscaping crew arrived 3 weeks later. They started before sunrise. By noon, the grass was gone. The old sprinklers were capped. Workers installed drip lines beneath fresh gravel. Native plants replaced the sections of lawn that had consumed the most water. Neighbors slowed their cars to watch. A few waved. Most kept driving. Nobody complained. Nobody questioned the work. By the end of the second day, the project was finished. Our water usage dropped almost immediately. So did the maintenance. No mowing, no fertilizer, no broken sprinkler heads. For the first time since moving into the neighborhood, our yard felt like it belonged where we lived. A week later, I ran into a neighbor while checking the mailbox. He looked at the new landscaping and nodded. Then he asked a question. "You got approval for all this?" I told him we had. I even mentioned the revision requests. He didn't seem surprised. He just nodded again. Then he said something I didn't understand until much later. "Good. Keep that email." Before I could ask what he meant, he walked back across the street. At the time, I thought he was being cautious. Months later, I realized he was trying to warn me. The first sign that something had changed wasn't a letter. It was the parking lot. For years, HOA meetings ended before sunset. Residents came in, approved budgets, discussed repairs, and went home. That October, people arrived early. Cars filled both sides of the street. Neighbors carried notebooks. Some walked in holding printed copies of the community handbook. 3 new board members had been elected the month before. Melissa Kane sat in the center seat. She arrived with a thick 3-ring binder tucked under one arm. Before the meeting started, she arranged colored tabs along the edge of the pages. Yellow, blue, red. When the first homeowner asked a question, Melissa didn't answer immediately. She opened the binder, turned pages, ran her finger down a highlighted paragraph. Then she read directly from the handbook. A homeowner asked about replacing a front door. Melissa opened the binder again. Another resident asked about landscaping. She turned more pages. A man in the back of the room asked about holiday lights. Melissa checked another tab. By the end of the meeting, the binder had spoken more than she had. Nobody complained. Nobody argued. People simply wrote notes. The meeting ended exactly on time. The minutes appeared online the next morning. A week later, I noticed fresh paint samples taped beside front doors on our street. 2 mailboxes had been replaced. A landscaping crew loaded mature shrubs into a trailer across the neighborhood. Nobody explained why. Nobody needed to. People had started adjusting. Driving home one evening, I passed a flatbed truck stacked with rolls of fresh sod. It stopped in front of a house that had installed desert landscaping the year before. Workers unloaded pallets before sunrise. By afternoon, the gravel paths were gone. The drip irrigation lines had disappeared beneath new grass. The sprinklers switched on before dinner. I slowed down at the stop sign and watched water run into the gutter. The homeowner stood in the driveway holding a hose timer. He looked up, saw me watching, then looked away. At the next meeting, Melissa placed the binder on the table before anyone sat down. A resident asked whether future landscaping projects would still be approved. Melissa opened the binder, turned 3 pages, placed her hand flat against the paper. Then she read a single sentence. Applications will continue to be reviewed according to community standards. She closed the binder, moved to the next agenda item. Nobody asked what those standards meant. Nobody asked whether anything had changed. After the meeting, residents folded their chairs and walked back to their cars without talking. Outside, a neighbor I recognized from our street stopped beside me. He glanced toward the community center entrance, then toward my yard. "You kept the approval email, right?" I nodded. He held my gaze for a second longer than necessary. Then he walked away. That night, I opened the email again. Approved as submitted. I printed another copy, placed it beside the first one in the kitchen drawer. Then I saved a second screenshot on my phone. The landscaping hadn't changed. The approval hadn't changed. But the neighborhood had. And I still didn't know why. The first photo appeared in the HOA portal on a Thursday afternoon. I saw the notification while standing in line at a grocery store. No subject line, no explanation. Just an alert that new documents had been added to our account. I opened the portal from my phone. 5 photos. Each one showed a different angle of our front yard. The agave near the walkway, the gravel border around the mailbox, the drip irrigation lines, the decorative stone beside the driveway. Every image included a timestamp. Someone had walked across our property that morning while we were at work. I zoomed in on the photos, looking for damage. A broken line, a dead plant, something out of place. There was nothing. The landscaping looked exactly the way it had looked the day the project was completed. Exactly the way it had looked in the approval documents. I drove home expecting to find a mistake. Instead, I found a bright orange notice taped to the front door. Architectural violation. Corrective action required within 14 days. Failure to comply may result in recurring fines. I read the notice twice before unlocking the door. Then I read it again at the kitchen counter. The violation wasn't a broken irrigation line. It wasn't dead landscaping. It wasn't poor maintenance. The issue was visual consistency. According to the notice, our yard no longer reflected the aesthetic standards of the community. The corrective action was listed near the bottom of the page. remove existing desert landscaping, restore turf grass, submit proof of compliance. The estimated replacement cost sat in my head before I even called a contractor. Thousands of dollars to undo a project the HOA had already approved. I opened the kitchen drawer and pulled out the approval email. Approved as submitted. I compared the approval date to the violation date. 18 months apart. Same address, same project, same yard. Different answer. That evening, I walked outside and noticed something I hadn't seen before. Across the street, another house had fresh sod. 2 doors down, workers unloaded new sprinkler heads from the back of a truck. At the corner, a neighbor rolled up a drip irrigation hose and loaded it into his garage. Nobody looked surprised. They looked busy, as if they had already accepted something I still didn't understand. The next morning, another document appeared in the portal. Fine schedule. $250 per week after the compliance deadline. The notice explained the process in precise detail. Inspection, reinspection, escalating penalties, possible lien procedures. The language felt automatic, as if the outcome had already been decided. I called the HOA management office. The representative confirmed that our application had been approved. Then she read directly from the violation notice. I asked what had changed. She paused, typed something into her computer, then repeated the same sentence. Current community standards require corrective action. I asked who changed the standards. She transferred me to voicemail. That afternoon, I printed the approval email again. Then I printed the violation notice. I placed both documents side by side on the dining room table. The pages looked almost identical. Same HOA logo, same property address, same account number. One document authorized the project. The other ordered us to remove it. By sunset, the landscaping crew across the street had finished laying new sod. The sprinklers turned on before they left. Water ran along the curb while temperatures pushed past 100 degrees. I stood in our driveway holding 2 pieces of paper that contradicted each other. One promised protection. The other threatened fines. And for the first time since moving into this neighborhood, I understood why people kept putting the grass back.
Help us grow. Join to Suburban Verdict.
The first thing I did was call the management office. I expected confusion, an apology, maybe a correction. Instead, the representative asked for our account number. I gave it to her. She opened the file and confirmed everything I already knew. Yes, the landscaping project had been approved. Yes, the violation notice had been issued correctly. Yes, the compliance deadline remained in effect. I asked how both things could be true at the same time. There was a pause. I heard keyboard clicks. Then she read directly from the notice. Current community standards require corrective action. The sentence sounded familiar, like it had been copied and pasted from somewhere else. I asked who changed the standards. She transferred me to another department. The second representative confirmed the approval date, confirmed the violation date, confirmed the fine schedule. Then she suggested I attend the next board meeting. I asked whether the board could overturn the violation. She couldn't say. I asked whether the approval email still protected us. She couldn't say that either. Before ending the call, she gave me a case number. Not an answer, a case number. I wrote it down anyway. That afternoon, I called the landscaping company that installed our yard. The owner remembered our address immediately. When I explained what had happened, he didn't sound surprised. He asked one question. Did the violation mention community standards? I said yes. He exhaled slowly. Then he told me he had seen similar notices before. Not often. but enough to recognize the pattern. I asked what homeowners usually did. He paused. Most people put the grass back. I looked out the kitchen window toward our front yard. The agave near the walkway, the gravel paths, the drip irrigation system. Everything the HOA had approved. Everything they now wanted removed. I asked whether fighting the notice worked. He didn't answer right away. Instead, he gave me the number of a water conservation specialist with the Southern Nevada Water Authority. Not an attorney, not a consultant. Someone who worked with homeowners transitioning to desert landscaping. I called immediately. The specialist answered on the second ring. I explained the approval, the violation, the deadline. Then I asked the question nobody else seemed willing to answer. Can they do this? He didn't respond immediately. I heard papers moving, a keyboard. Then he asked for the name of our community. When I told him, he asked me to email the approval documents and the violation notice. Nothing in his voice sounded surprised. Nothing sounded urgent. But he didn't tell me to put the grass back. That alone felt different. Before we ended the call, he said something I wrote down word for word. Don't remove anything until we review the documents. That night, I placed the violation notice beside the approval email on the dining room table. Then I added the case number from the management company. 3 pieces of paper. 3 different answers. Outside, the sprinklers across the street switched on just after sunset. Water flowed into the gutter, while our Xeriscape sat dry under the porch light. For the first time since the violation arrived, I stopped asking why people put the grass back. I started asking why some people didn't. The inspection happened on a Saturday morning. At 8:12, a white SUV stopped in front of our house. The logo on the door matched the one at the bottom of the violation notice. 2 people stepped out, carrying clipboards. Neither knocked, neither rang the doorbell. They walked directly to the edge of the driveway and started taking pictures. One crouched beside the drip irrigation lines. The other zoomed in on the agave near the walkway. Then they moved to the gravel border around the mailbox. Every angle, every detail. I opened the front door before they reached the side yard. One introduced herself as a compliance inspector. The other never looked up from his tablet. I asked whether they needed access to the property. She pointed at the violation number printed on her clipboard. Then she kept taking pictures. The inspection lasted less than 10 minutes. By the time they drove away, 2 neighbors had stepped outside. One checked the mailbox, another trimmed a hedge that didn't need trimming. Nobody said anything. Nobody had to. That afternoon, a new document appeared in the portal. Second inspection completed. Non-compliance confirmed. 7 days remaining. I printed the notice and taped it beside the approval email on the refrigerator. 7 days. The next morning, I crossed out the first square on the kitchen calendar with a red marker. By sunset, another day was gone. 3 days later, I found a plastic marker pushed into the gravel near the sidewalk. Bright orange, easy to read from the street. Architectural review pending. I pulled it out before dinner. The next morning, another marker appeared. This time, it had been pushed closer to the driveway. Anyone driving past could see it. People slowed down when they reached our house. Dog walkers crossed to the other side of the street. Neighbors who usually waved kept driving. One afternoon, I watched a pickup truck roll past our yard twice in less than 10 minutes. The second time, the passenger held a phone against the window. The truck never stopped. That evening, I opened the community Facebook group. Someone had posted a photo of our front yard. The house number had been blurred. The comments filled quickly. Nobody asked why the project had been approved. Nobody mentioned the email. The conversation moved straight to compliance. Rules exist for a reason. Property values matter. Standards protect everyone. By midnight, dozens of people had reacted to the post. The next morning, I stepped outside to pick up the newspaper. The street was quiet. A neighbor jogging toward our house crossed to the other sidewalk without slowing down. Another backed out of the driveway across the street and stared straight ahead. At 6:30 that evening, the sprinklers switched on across the street. Water ran into the gutter exactly the way it had every day since the new sod was installed. I watched from the porch while the timer clicked through each zone. 6 minutes, then another zone, 6 more minutes. The schedule never changed. The message didn't need to change either. The landscaping hadn't changed, the approval hadn't changed, but the neighborhood had. That afternoon, another notice appeared in the portal. Final compliance reminder. Failure to restore turf grass within 7 days may result in recurring fines and additional enforcement actions. No explanation, no hearing date, no contact person. Just a countdown. For the first time since the violation arrived, the yard stopped feeling like part of our home. It felt like evidence. The specialist from the Southern Nevada Water Authority called back on Tuesday morning. When my phone rang, the compliance deadline taped to the refrigerator showed 6 days remaining. He didn't mention the violation notice. He didn't ask about the board. He asked for our water bills. 10 minutes later, I emailed 12 months of statements. By the afternoon, he sent back a chart. The difference was impossible to miss. The month after we installed the Xeriscape, our water usage dropped sharply. The line on the graph stayed lower every month after that. No estimates, no opinions, just numbers. He asked whether anyone from the HOA had requested those records. No one had. He asked whether the violation notice mentioned water consumption. It didn't. Then he asked whether anyone from the board had inspected the irrigation system. I thought back to the photos in the portal. The inspectors had photographed the gravel, the agave, the mailbox border. Nobody had checked the drip lines. Nobody had measured water use. The specialist stayed quiet for a moment. I could hear typing in the background. Then he asked me to send the original landscaping application, not the approval email, everything we submitted before construction started. I opened the folder on my laptop and started scrolling. The file was bigger than I remembered. Pages of measurements, property maps, irrigation plans, photos of the old lawn. Halfway through the application, he stopped me. Go back. I scrolled up. Right there. At the bottom of the page sat 2 logos. The first belonged to our HOA. The second belonged to the Southern Nevada Water Authority. I had looked at that page dozens of times. I had never noticed it. Beneath the logos, a single sentence appeared in small print. This project may qualify for conservation incentives. The specialist asked for the application date. Then he checked something on his computer. More typing, more silence. When he spoke again, his voice hadn't changed. Your community participated in this program. I looked toward the violation notice sitting on the kitchen counter. Restore turf grass. The words felt different now. I asked the question everyone else had avoided. Can they do this? He didn't answer. Instead, he emailed me a single page. No introduction, no explanation. Just one paragraph highlighted in yellow. I read it once. Then I read it again. An association may not prohibit or unreasonably restrict water-efficient landscaping. That was it. One sentence. No legal jargon, no complicated language, just a rule that seemed impossible to misunderstand. The specialist didn't tell me the HOA was wrong. He didn't tell me we would win. He didn't offer advice. He only asked one more question. Did they give you a reason beyond community standards? I looked at the violation notice again. The answer was still no. His response never changed. Don't remove anything. After the call ended, I printed the highlighted page and placed it beside the violation notice. For the first time since this started, the two documents contradicted each other. Outside, a landscaping crew rolled fresh sod across a front yard 2 streets over. I watched from my car as workers connected new sprinkler heads and covered the drip lines underneath. The homeowner stood in the driveway with folded arms. When the crew finished, he signed the invoice without looking at the yard. Then he went back inside. Driving home, I stopped noticing the grass. I started noticing the yards that hadn't changed. A gravel pathway near the community entrance, a row of agave beside a corner lot, a drip system running beneath desert shrubs. There weren't many, but they were there. I parked across from one of them. A woman stepped outside carrying a recycling bin. When she saw me looking at her yard, she smiled. The first smile I'd seen in days. I asked how long she'd had the landscaping. About 2 years. I pointed toward the agave near the driveway. No problems with the HOA? Her smile faded. She looked down the street before answering. Not anymore. Before I could ask another question, she wheeled the bin back inside. That evening, I placed the highlighted page beside the approval email, beside the violation notice, beside the countdown taped to the refrigerator. For the first time since the inspection started, one of those documents came from someone the HOA couldn't overrule. And that raised a bigger question. If Nevada had already settled this issue, why was everyone still putting the grass back? The hearing notice arrived 2 days later. Not by mail, not by email. It appeared in the HOA portal at 6:03 a.m. Mandatory compliance hearing. Attendance requested. Failure to appear may result in additional enforcement actions. The meeting was scheduled for the following Tuesday, 3 days before the fine deadline. I read the notice twice. The countdown taped to the refrigerator showed 4 days remaining. That afternoon, I called the management office again. This time, I didn't ask about the violation. I asked whether the board had reviewed Nevada law. The representative placed me on hold. When she returned, her answer was short. The hearing panel will review all relevant information. I asked whether the board was aware of NRS 116.330. Another pause. More keyboard clicks. Then the same response. The hearing panel will review all relevant information. The deadline stayed in place. The inspections continued. New notices kept appearing in the portal, as if the hearing had already happened. That evening, I drove back through the neighborhood. I stopped near the house with the agave beside the driveway. The same woman stepped outside to collect a package. When she recognized my car, she walked over. I told her about the hearing notice. She nodded. No surprise. I asked whether she had received one too. She looked toward the street before answering. Not exactly. I waited. She shifted the package against her hip. They said I could keep the landscaping if I replaced the gravel border and added more plants. I looked at her yard. Nothing about it matched our violation notice. I asked what changed. She shrugged. I stopped arguing. Before I could ask another question, she added something else. Most people do. Then she carried the package back inside. Driving home, I started noticing details I had missed before. new sod covered yards where drip lines still poked through the soil. Outside one garage, unused sprinkler heads sat beside a trash bin. A roll of landscape fabric leaned against another driveway, waiting for pickup. The changes looked recent. Not because people wanted them to, because they wanted the process to end. The hearing packet appeared in the portal later that night. 32 pages filled with timelines, procedures, and references to architectural standards. I kept scrolling, waiting to find something about water conservation or Nevada law. It never appeared. Near the end of the packet, one sentence had been highlighted. Community aesthetics may require modifications beyond previously approved plans. I read it again. Then I looked at the highlighted page from NRS 1116.330 sitting beside my laptop. The two documents weren't arguing about landscaping. They were arguing about authority. The next morning, I moved the Nevada statute to the front of the folder. For the first time since this started, the question wasn't whether the HOA knew the rules. The question was whether they had found a way around them. And if they had, how many people had already given up trying to fight it? The hearing took place on a Tuesday evening. The clubhouse parking lot was already half full when I arrived. Inside, the meeting room looked exactly the way it had during every budget presentation and holiday planning session. Folded chairs, coffee urns, a long table at the front of the room. Only one thing was different. My address appeared on the agenda. 3 board members sat behind nameplates. Melissa sat in the center. A management representative opened a laptop beside her. Nobody mentioned the inspections. Nobody mentioned the orange markers. Nobody mentioned the photos posted online. The conversation started with procedure: account number, property address, violation date, compliance deadline. When it was my turn to speak, I placed a copy of NRS 116.330 on the table. Melissa glanced at the page. Then she looked back at the hearing packet. She didn't argue with the law. She didn't question the wording. Instead, she pointed to another document, the Community Design Guidelines. According to the board, the violation wasn't about water efficiency. It was about visual consistency. The gravel border, the spacing between plants, the overall appearance of the front yard. I opened the approval email. Approved as submitted. Melissa nodded. Nobody disputed the approval. Nobody denied the project had followed the process. The board's position was simple. Community standards evolve. Approvals don't guarantee permanent compliance. I asked when those standards changed. Melissa turned to the management representative. The representative opened a folder. No date, no amendment, no member vote. Just an updated interpretation. One board member thanked me for my commitment to water conservation. Another said the association supported sustainable landscaping. Then Melissa slid a new document across the table. Extension agreement. If I signed it, the fines would pause for 30 days while the board conducted an additional review. If I refused, the original deadline would remain in effect. I asked whether the review would include Nevada law. Melissa didn't answer directly. She said the board would consider all relevant information. The same sentence. Again. I looked around the room. A few residents sat quietly in the back row. Nobody spoke. Nobody asked questions. One man lowered his eyes when I looked in his direction. Another folded the hearing agenda and slipped it into his pocket. The meeting ended without a decision. As I walked toward the parking lot, the woman with the agave yard caught up to me near the exit. She didn't stop walking. She kept her eyes on the sidewalk. Then she said something quietly. I signed the extension. Before I could respond, she unlocked her car and drove away. That night, I placed the unsigned agreement beside the violation notice. The fines hadn't been removed. The deadline hadn't disappeared. The law hadn't changed. The board had simply found another way to buy time. And for the first time, I understood what the hearings were really for. Not to decide who was right, to decide who got tired first. The morning after the hearing, I drove the neighborhood again. Not to look at lawns, to look for patterns. The extension agreement sat unsigned on the passenger seat. For weeks, I had been asking whether the HOA had the authority to force homeowners to restore grass. Now I was asking a different question. Who had they decided not to fight? I started near the entrance of the community. The first Xeriscape yard I found looked familiar. Gravel pathways, agave near the driveway, low-water shrubs arranged around decorative stone. No orange marker, no inspection notice, no fresh sod. I parked across the street and checked the county records on my phone. The landscaping permit was newer than ours. I drove to another block. Same result. Different house, different owner, same type of yard. No enforcement. By noon, I had photographed 6 properties with landscaping that matched our application more closely than our own yard did. None showed any sign of compliance action. No markers, no warning letters taped to the door, no crews reinstalling grass. Back home, I spread the photos across the kitchen counter. For the first time since the violation arrived, I stopped comparing our yard to the rules. I started comparing the rules to the neighborhood. The numbers didn't make sense. That afternoon, I opened the community Facebook group again. The post about our house had disappeared. I searched older discussions. Landscaping complaints surfaced every few months. The wording always sounded familiar. Property values, neighborhood appearance, community standards. But the outcomes never matched. One homeowner mentioned receiving a warning. Another described a conversation with a board member. A third thanked the architectural committee for approving an exception. The rules stayed the same. The consequences changed. I called the woman with the agave yard. She answered after the second ring. I asked whether she had ever received a violation notice. She said yes. I asked what happened. There was a long pause. Then she gave me an address. Drive by that house. No explanation, just an address. The property sat at the end of a quiet cul-de-sac. The front yard looked like a landscaping brochure. Mature agave, decorative stone, a dry creek bed running beside the driveway. No grass, no sprinklers, no orange marker. A compact SUV sat in the driveway. The license plate frame carried the logo of the HOA management company. I stayed there for less than a minute, long enough to notice a shipping label on a package near the front door. The last name matched one of the surnames on the hearing agenda. Driving home, I remembered something the woman had said outside the clubhouse. I signed the extension. At the time, I thought she meant she had lost. Now I understood what she meant. She had stopped asking questions. That evening, I called her back. This time, she talked. Not about the law, about the process. The first notice had arrived almost a year earlier. After that came inspections, then reminders, then meetings, then another review. Every time she challenged the decision, the timeline reset. Every time she asked for clarification, someone promised to look into it. Nothing changed, except the amount of time she spent thinking about her front yard. Eventually, the board offered a compromise. Replace a few plants, move the gravel border, install additional shrubs. The violation would disappear. She accepted. Not because she agreed, because she wanted her weekends back. Before hanging up, she said something I wrote down. Nobody wins these fights. They just decide how much of your life they're willing to take. After the call, I looked at the unsigned extension agreement again. 30 more days. 30 more days of inspections. 30 more days of notices. 30 more days of wondering whether another orange marker would appear outside. The agreement didn't pause the conflict, it extended it. For the first time since this started, I understood why the board never argued about the law. The law wasn't the point. The process was. The longer it lasted, the more likely people were to surrender. I placed the extension agreement beside the violation notice. Then I placed the photographs of the other yards next to both. 6 houses, 6 exceptions, 1 question. If the rules applied to everyone, why did enforcement seem to depend on who lived behind the front door? The next morning, I stopped calling the management office. I stopped leaving voicemails. I stopped asking the board to explain the difference between an approval and a violation. The extension agreement stayed unsigned on the kitchen counter. The deadline was still there. The fines were still there. The orange marker was still outside. But after the hearing, the problem looked different. The HOA wasn't confused. The board had chosen a position and was waiting to see how long we could afford to stand against it. So I sent everything to the Southern Nevada Water Authority. Not as a complaint, not as a demand, just as a record. The approval email, the violation notice, the hearing packet, the water usage chart, the photos of the orange marker, the pictures of the other yards. I attached the extension agreement last. The subject line was simple: request for documentation review. Then I pressed send. For 3 hours, nothing happened. At 2:17 p.m., the specialist replied. No promises, no opinion, no legal threat. Just one sentence. We will document the concern. That was all. I read it twice. It didn't sound like help. It sounded like a file had been opened somewhere the HOA did not control. The next morning, the white SUV did not return. At first, I didn't notice. I had gotten used to checking the street before opening the front door, checking the gravel before stepping outside, checking the portal before making coffee. That morning, the street stayed empty. No inspectors, no tablets, no new photos. The orange marker still stood near the sidewalk, but nobody came to replace it, nobody moved it closer to the driveway, nobody photographed it. By noon, the portal showed no updates. By evening, the sprinklers across the street turned on, like they always did. Water ran along the curb. A dog walker passed our house, slowed near the marker, and kept going. The next day was the same. No message, no call, no new notice. The silence should have felt peaceful. It didn't. It felt procedural, like someone had paused a machine without turning it off. On the 3rd morning, I opened the front door and stopped. The orange marker was gone. No one had knocked, no one had left a note, no one had sent a message. The gravel near the sidewalk still showed the small hole where the plastic stake had been pushed into the ground. I stood there for a moment, looking at that empty spot. It was the first thing the HOA had removed without asking us to do it for them. I checked the portal before breakfast. Nothing. At lunch, still nothing. At 4:42 p.m., a new document appeared in our account. Compliance status update. I opened it on my phone. The first line was dated that afternoon. The second line listed our property address. The third line said the matter had been reviewed. I kept reading. Following additional review, the association has elected to close this matter without further enforcement action. No apology, no explanation, no mention of NRS 116.330, no reference to the approval email they had ignored for weeks, no acknowledgement of the inspections, no acknowledgement of the orange marker, no acknowledgement of the public pressure. Just close this matter. I read the sentence again. The fines had been removed from the account. The compliance deadline disappeared from the portal. The hearing file had been archived. The violation status changed from open to closed.
Nothing in the yard changed. The agave stayed where it was, the gravel stayed where it was, the drip irrigation line stayed buried under the stone. The only thing that changed was the paperwork. That evening, I walked through the neighborhood. Not to count lawns, not to look for exceptions, just to see what the street looked like after the threat disappeared. The house across from us still had new sod. The sprinkler heads were still running. The homeowner who had signed the invoice in his driveway had a brown patch near the curb where the water didn't reach. 2 streets over, another yard had fresh grass laid over soil that still showed pieces of landscape fabric beneath it. The next board meeting agenda appeared online the following week. No mention of our case. No mention of water conservation. No mention of architectural violations. A new item had been added near the bottom. Landscape Guideline Review. That was all. No admission, no explanation, just a review. At the meeting, Melissa sat at the center of the table with the same binder in front of her. The colored tabs were still there. The handbook was still there. The tone was still the same. A resident asked whether homeowners with approved Xeriscape projects would receive clarification. Melissa opened the binder, then closed it again. The management representative answered instead. Updated guidance will be provided after review. Nobody asked when. Nobody asked why. Nobody asked whether prior violations would be refunded. The room moved on. Budget update, pool maintenance, community lighting. The machine kept running. Only one part had been adjusted. When I got home, I opened the kitchen drawer and pulled out the approval email. The first copy had creases from being handled so many times. The second one was still clean. I placed both beside the retraction letter. 3 documents from the same HOA. One approved the yard. One ordered us to remove it. One closed the case, without admitting the first 2 had ever contradicted each other. That was the part that stayed with me. Not the violation, not the hearing, not even the fines. It was the fact that the system could reverse itself without ever saying it had been wrong. The next morning, our drip irrigation system turned on before sunrise. No spray hit the sidewalk. No water ran into the gutter. The desert plants barely moved in the warm air. Across the street, the sprinklers came on a few minutes later. Water arced across the new grass and spilled onto the concrete. Nothing about that looked illegal. Nothing about our yard had looked illegal either. The difference was never the landscaping. It was who had been willing to keep saying no. The HOA never admitted they were wrong. They didn't have to. The marker disappeared, the fines disappeared, the violation disappeared. But the question stayed. How many homeowners had already paid to fix a problem that never should have existed?